I'm attorney Nick Alcock, and if you've been charged with a felony in Maricopa County, Arizona, and you're going to Superior Court, I'm going to give you some pointers on plea agreements and some things you need to take into consideration. First of all, your typical felony case does not take weeks. It takes much, much longer. The more serious the case, it could last years even. So typically people have a certain amount of time to gather evidence, look at the documents, talk with their attorney, and really understand the nature of the charges against them. If you are charged with a felony, however, on occasion, a prosecutor will say, look, here's a plea agreement, it's take it or leave it, very short window to consider it. And some people very early in the process are a bit hard by that because it was a good plea agreement. It was a plea agreement that, and I hate saying good plea agreement because no person wants to sign a plea agreement. Relatively, it's good. So the county attorney has policies and procedures. So if you're charged with a certain level of felony, you can expect a policy offer to be within a certain range based on a book that they've got. And they say, okay, you're charged with a class 4 felony. This is what is typically going to be offered to somebody based on the facts of the case, the criminal history, things like that. Sometimes they'll make a plea agreement which is way reduced, quite a big departure from that to the typical plea offer that's given. But they might say, hey, look, it's open for a week, take it or leave it. And if you don't take it, then the case is going to go to trial and we'll see you in court. That can happen on occasion. Usually in the arcs of these cases, though, you're given more time and it's not like a now type of situation. However, trick of the trade, if you go to the RCC and you've got a status conference, it's also set for a preliminary hearing, and they make a plea offer, once you reject formally that plea offer and you set it to trial, or the trial group, so say that you're at that RCC level at the very beginning of a case, you've got 2 court dates, you've met there a couple times, and they've extended a plea offer to you, and they've given you a month to think about it, and you're like, no, I want to take my case to trial group. So then what will happen usually is that there'll be a little hearing, and the prosecutor will say, well, look, we have extended this plea offer, this is what we are extending, and the plea could get substantially worse. That's called a Donald advisement. So if you hear that, understand that those words actually have meaning, and it can be that that will be the last time you'll ever see that plea agreement. If you take your case to trial group, the plea can get better, it can get worse, it can stay the same. They don't have to offer a plea in some cases, and sometimes they don't. Most of the time in trial group that they will. But in a situation like the one where you go to the RCC, you reject the plea agreement there, you set your case to trial group, there'll be a fork in the road moment at some point. I like to describe it this way. At some point, you'll know that you've run out of time. Sometimes prosecutors will say, yeah, on paper, the deadline is this, but we would be willing to extend it. So there's a little conversation that happens with the attorney. At some point, that willingness to work, and at some point, that willingness to kind of, keep things kind of going along with these continuances, at some point that ends. And when that ends, it's serious. And it's serious because you're setting your case to trial, and absent some other extraordinary circumstance, you've rejected the plea agreement and it's going to trial. Now, say the prosecutor can't find a witness, say that the police officer gets sick, say that the police officer is in the reserves and is called up and sent to Iraq. Things like that can happen, and then a plea can be reconstituted or a different plea can be made. But please be aware of the fact that anytime that you have a criminal case, there are no guarantees. If you're the RCC and you reject that plea agreement, there are no guarantees that you're going to get another plea once you set your case to trial group. At trial group, once you get to that deadline, the fork in the road moment, there are no guarantees that the plea is going to get better. So sometimes people talk about the third plea, and that's kind of a jailhouse rumor. It's been going on since, over 20 years since I started practicing. 22 years I've heard about, well, this is the second plea, I want my third plea. The third plea can happen, but also in many cases doesn't happen. So you have a plea at the RCC level, and then you negotiate a plea before the case really gets set to trial. And then say the case gets set to trial, you reject that second plea, and it's headed towards trial in that situation, say that they can't find a witness, that's when that magical, mystical third plea is offered. In some cases, there's 7 pleas that are offered. In some cases, there are 15 pleas, but that's the idea behind the third plea. So people will say, look, reject that plea agreement because, don't worry about it. They'll make another plea. That's a bit of a rumor. There are no promises or guarantees. Anytime that you are formally rejecting a plea agreement, you're in court and you're telling the judge, I know the plea agreement exists, it's been described to me, and I don't want it. Anything can happen from that point forward. So how do you do a good job as a criminal defense attorney with this type of situation? What are the things that you can really leverage to get good outcomes? If you have very good relationships with the prosecutors, and if you are a straight-laced attorney and you play it correctly and you're not taking any shady chances, the prosecutors many times will open up and they'll reveal information to you about really what it is they're thinking. And they'll say things like, look, I think I can do better if he rejects this plea agreement. Give me a bit more time. I'll go speak with my supervisor. So they'll say things like that, and they'll give us some amount of an idea as to where things are going. The other thing that you can do is that you can set a settlement conference in front of a judge. Settlement conference can be very, very valuable because it puts that prosecutor on record as far as what a fair plea offer is. And you also can get in preparation to do the settlement conference. It's a good opportunity to speak with the prosecutor to really find out about how low that they can go. The more engaged you are with the prosecutor, the more on top of the case you are as a defense attorney, the more you're communicating. The worst thing that you can do as a defense attorney is never talk to the prosecutor and wait to the very last minute. Believe it or not, that does happen, and I've seen that happen on many occasions, because what happens is, the defense attorney will call up their client and say, hey, here's your plea, and it's take it or leave it tomorrow. But that defense attorney didn't really do their work. They didn't communicate with their client. They didn't communicate with the prosecutor. So they don't even really know what's going on in the case until it gets to the very, very end. One way around surprising clients is constant engagement with client, constant engagement with the prosecutor, and more than just discussing the case, really trying to find out, look, what's the plea offer that you can get to? At some point, if you work that way, you can really know, okay, we're at the fork in the road. We're at the moment where you have to decide, this is the best plea agreement that we've negotiated. It's very likely not going to be extended after this day. You have to decide whether or not you want to take it. We don't charge for trial. We don't charge a trial fee. And so that's something which is very near and dear to my heart. I don't believe in it. And so it's a decision that you make. I work for you. I have to communicate the plea offer to you, and then it's up to you as far as whether or not you want to accept it. In some cases, we know the case is going to trial from the very, very beginning. In other cases, the case can plea out at the very, very, very last minute. The very last second, like literally the jurors are coming in to be picked, and the prosecutor's like, you know what, here's the plea offer that you've been asking for all along, because they recognize that their case is a little bit weaker than what they were thinking. So if you have a felony case, the thing I urge you to consider is stay in communication with your defense attorney. Make sure that there are no surprises. And you can go to your defense attorney and say, hey, look, I need to know what the plea offer is. I need it in writing, and I need to know what the deadline is, so that you have an obligation in this as well. You've got, this is your life. And so if we're talking about your life, stay in communication with your defense attorney. Some people like to put their heads in the sand. They don't want to think about it. They're like, oh, I don't want to think about it. That type of stuff. I don't blame you, because who wants to think about a criminal case? However, that can really, really hurt you, because if you're not prepared, if you hadn't read the evidence against you, you haven't looked at the police reports, and you roll into court and that's your deadline at that day, you could find yourself in a world of hurt, because reflexively you want to reject that plea agreement. You look at the plea and you're like, and it's a mourning process sometimes to take a plea agreement. It's a very, very significant event in your life. So it deserves more than 5 minutes or a day. So sometimes people are just like, I'm not psychologically ready to take this plea agreement, but then they find themselves in trial winding up getting much more time because that plea wasn't communicated earlier. And our job as defense attorneys is to make sure that communication is happening, make sure that as much as a client sometimes wants to keep their head in the sand, we're talking with them, we're communicating with them, and we're really acting as a partnership, so that we know what's going on with the case, but also we want to learn from our clients. We want to talk to them about what they know about the case, so we can do a better job either winning the case at trial or negotiating the very best plea agreement possible. So if you find yourself in this situation, I urge you, stay in communication, stay engaged with your defense attorney. Make sure that you understand what the plea agreement is. Make sure you understand what the range is. And if you ever have any questions or concerns, we offer a free consultation. 602-989-5000 is our number. That's 602-989-5000. Give us a call, come in here, we can look at the paperwork. Obviously, a full case diagnosis can't be done, especially a case which is more advanced. But I think you'll find that it can be of tremendous benefit to have a second set of eyes look at your case and give you an idea as to what it is you're facing. So this video is a little bit longer than most, but we are talking about felony cases. We're talking about your life. We're talking about whether or not you should take a plea agreement. Ask your defense attorney, am I at the fork in the road moment? Is this real? Is this really the last time that you think that I'll be able to get a plea agreement? Communicate with them, understand your case, and you're much, much, much more likely to get a good outcome. Thank you so much for watching. If you need anything, we're here for you. 602-989-5000. Thank you so much for watching.